Good morning. I hereby call to order the 16th meeting of the Pennsylvania Public Utility Commission for the year 2025. Welcome everyone joining us here in the room today, as well as those joining us on the live stream. Please stand for the Pledge of Allegiance. At today's meeting, which is open to the public, the Commission will act on various matters. Since adequate forums have been made available for public participation in cases before the Commission, there's no opportunity for the public to address the Commission at this public meeting. Public meeting motions, statements, and video will be available on the Commission's website later today. We do have a quorum of Commissioners present today, with Vice Chair Barrow joining us remotely. Good morning, Vice Chair Barrow. Are you with us?
Good morning, Chairman.
Thank you. The first matter on this morning's agenda is the approval of the minutes of the meeting of July 24th, 2025. I would like to recognize Commissioner Yonora as the editor of the minutes. Commissioner Yonora.
Chairman, I reviewed the minutes of the July 24th, 2025 public meeting and move that they are approved as submitted.
You've heard the motion by Commissioner Yonora. Is there a second?
Second.
Second by Commissioner Zarfis. Any discussion? Hearing none. All those in favor, please say aye.
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 Those opposed, no. The ayes have it, and the minutes are approved by a vote of 5-0. Let us begin on page 1 of today's agenda and matters presented by Director Gramola and the Bureau of Administration. I move that the Commission adopt an omnibus motion, beginning with the first item on page 1 regarding the assessment of pipeline operators for the 2025-2026 fiscal year, and continue the omnibus motion to include both items on page 2 and both items on page 3, ending the omnibus with a general assessment upon public utilities for the 2025-2026 fiscal year. Is there a second?
Second.
Seconded by Commissioner Zarfis. Any discussion? I do have a statement on the first item on page 2, the assessment pursuant to the Pennsylvania Underground Utility Line Protection Act, and I am submitting that for the record. Any further comments? Hearing none. All those in favor, please say aye.
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 Those opposed, no. The ayes have it, and matters are approved by a vote of 5-0. Turning to page 4, and a single matter presented by Director Yoder in the Bureau of Audits. I move that the Commission adopt the audit report of the Borough of St. Clair's Purchase Power Adjustment Clause and release the report to the public. Is there a second?
Second.
Seconded by Commissioner Zarfis. Any discussion? Hearing none. All those in favor, please say aye.
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 Those opposed, no. The ayes have it, and matters approved by a vote of 5-0. Turning to page 5 of today's agenda, and matters presented by Director Hafner in the Office of Special Assistance. It should be noted that the matter on page 5 regarding the joint application of the Appalachian Utilities Incorporated and Pennsylvania American Water Company has been postponed to the public meeting of September 11th, 2025. Turning to page 6 of today's agenda, I move that the Commission adopt a proposed opinion and order regarding the formal complaint of Tamika Anderson. Is there a second?
Second.
Seconded by Commissioner Zarfis. Any discussion? I do have a motion in this matter, and I would ask Vice Chair Barrow to chair the meeting. Vice Chair Barrow.
Chairman, you're recognized for purposes of your motion.
Thank you, Vice Chair Barrow. Before the Commission for consideration today are the exceptions of Tamika Anderson in response to the initial decision issued by Administrative Law Judge F. Joseph Brady. Ms. Anderson filed a complaint against Philadelphia Gas Works, alleging that there were incorrect charges on her bill. She was experiencing a reliability, safety, or quality problem with her utility service, and that she would like a payment arrangement. In his initial decision, the ALJ denied Ms. Anderson's complaint in its entirety. Ms. Anderson then filed exceptions. On June 13, 2025, the Commission issued an order dismissing Ms. Anderson's exceptions related to allegations of incorrect charges on the bill and any reliability, safety, or quality problem. The June 13th order, however, did not address Ms. Anderson's request for Commission to issue payment arrangement. Instead, the order directed PGW to submit information regarding the amount of Ms. Anderson's updated outstanding account balance, including what amount of her outstanding balance was accrued while she was enrolled in PGW's Customer Assistance Program. On June 23, 2025, PGW filed an additional exhibit showing Ms. Anderson's current arrearage of $13,793 and stating that $4,868 of that amount accrued while she was enrolled in CAP. Ms. Anderson's complaint with regard to her request for a commission-issued payment arrangement is now ready for disposition. In light of the record established in this case, I find that Ms. Anderson has failed to satisfy her burden that she is entitled to a commission-issued payment arrangement. The decision on whether to direct a utility to provide a payment arrangement for a customer often has many variables. On one hand, utilities are entitled to be compensated for service they provide. On the other hand, utility customers have a right to safe and reliable utility service at just and reasonable rates. A payment arrangement helps balance these two sometimes competing interests. However, the Commission must also reconcile two competing goals, providing an individual customer with an opportunity to retain service versus insulating the overall utility customer base from the harm of undue costs. There is no bright line test when balancing these two competing interests. The Commission must be guided by the ultimate public interest. The record in this case is complicated. Ms. Anderson has never received a Commission-issued payment arrangement. Therefore, the Commission can direct PGW to provide her with one. Oftentimes, a payment arrangement is the best way for a customer to repay arrears. However, PGW has provided Ms. Anderson with several payment arrangements which she has not kept. Furthermore, record evidence demonstrates that at the time of the hearing, Ms. Anderson had not made a payment on her account for more than 5 years. Ms. Anderson did attempt to make 4 payments during those 5 years by check, but each check was subsequently returned. Following her hearing with ALJ Brady, Ms. Anderson made 2 cash payments totaling over $700. In addition, Ms. Anderson has been in and out of PGW's CAP during this time. As a result, whether or not to give Ms. Anderson a commission-issued payment arrangement is a difficult decision. On balance, in this case, I find that Ms. Anderson's history of failure to make payments leads me to the determination that she should not be afforded a commission-ordered payment arrangement. While Ms. Anderson has recently made 2 cash payments to PGW, she did not make any payments during the previous 5 years and has accrued an arrearage of over $13,000. I believe it is in the public interest to deny her request and uphold the underlying initial decision in order to protect PGW's overall customer base from the risk and harm of undue costs. Therefore, I move that 1, the initial decision of Administrative Law Judge F. Joseph Brady issued at this docket and dated October 28, 2024 is affirmed consistent with this motion. 2, that the exceptions filed by Tamika Anderson dated October 30th, 2024 are denied. And 3, that the Office of Special Assistance prepare an order consistent with this motion. Thank you, Vice Chair Barrow.
Thank you, Chairman. You've heard the motion. Is there a second? Is there a second for the motion?
Second.
Second by Commissioner Yanora. Any discussion on the motion?
Vice Chairman, this is Commissioner Coleman. I do have some verbal remarks.
Go ahead, Commissioner Coleman.
Thank you, Vice Chairman. I know we rehash this territory on a regular basis, but I thought this morning that it was worthy of a couple of comments. First, I want to commend the chairman for his leadership on this matter. These are never easy, simple cases to decide. However, this one this morning, I think, really strikes a couple of points with me. The first of which takes us back to Chapter 14 and what Chapter 14 had provided to this commission in terms of the discretion of issuing payment arrangements. And the language that is embedded or was embedded in Chapter 14 gave this commission the discretion to issue a payment arrangement. And the language is may issue a payment arrangement, not shall issue a payment arrangement. I think over time, this commission has gotten accustomed to issuing a payment arrangement in any circumstance. And unfortunately, I'd like to think that's the case here. That I cannot imagine that under any credit analysis criterion that anyone would issue a payment arrangement to Ms. Anderson after you have heard the troubled payment history in the chairman's motion. 5 years with zero payment. Now racking up over $13,000 of accrued charges to what most likely is going to be the ratepayers of the Philadelphia Gas Works. Arguably, nobody wins here with the exception of Ms. Anderson, that it's highly likely that she's going to walk away from this situation and leave the uncollected balance in the hands of PGW and the ratepayers of PGW to pay. The discretion that has been granted to this commission, I believe, comes with trust. The trust of this commission to use all of our available resources to make the very, very best decisions we can. And sometimes those are hard decisions. Those aren't easy. And these cases are very difficult. They're emotional, they're personal, and realizing the consequences to the people involved here. However, again, I think the record evidence here is overwhelming that Ms. Anderson should not receive a payment arrangement from this commission. Now, the question has been raised as to, well, what is the effectiveness of the commission-issued payment arrangements that we grant? And I think that's a reasonable one. Again, in that trust that has been granted to this commission in using that discretion in making payment arrangements. And so I did just a quick little survey to get a sense of how effective are those commission-issued payment arrangements, and just took a small sampling just to get a flavor of, how effective is the action that we're taking here as this organization. And we looked at a 5-year period, going back 5 years, and a sample size of 398 commission-issued payment arrangements. And how many of those payment arrangements remain active and that were followed by the person that we issued the payment arrangement to? And the answer to the question of how many of those 398 anybody made good on? One payment arrangement. And so I'm hoping that this morning, maybe this is a turning point for all of us collectively. This is a highly charged discussion of how to deal with customers who simply cannot financially afford to pay their bill, i.e. the Tier 1 customers who maybe deserve a special treatment, to the Tier 4 customers who have the ability to pay but choose not to. And that's, in my mind, is problematic. And it should be problematic for all of us. My data sample is just a small slice of what I believe is happening in the process. And what I would like to propose this morning is to charge our executive director, Director Barrier, to take a deeper dive into what has been the success of the commission-issued payment arrangements in a broader sense than what I've been able to do, and share that data with us to see what we may be able to do collectively. This is not suggesting that we cut off people from receiving commission-issued payment arrangements. I think it is about restoring the trust that has been granted to us by the legislature to make the very best decisions for all customers, low-income customers as well as good-paying customers. And when I look at the Philadelphia Gas Works in particular, and the number of accounts that are $10,000 or more, some are over $20,000. 398 of them. 398. So we're talking over $4 million, $5.5 million of arrearages that will ultimately end up on the backs of good-paying ratepayers. And I just think this is really an issue of fairness. And I'm hoping that this morning will be a turning point and gives us an opportunity to take a deeper dive to see what we can do collectively and effectively for all customers, those who can afford to pay and those who cannot afford to pay. But I think at this point, there are no winners here today, in this case, except for Ms. Anderson, and that, I believe, is truly unfortunate. Thank you, Vice Chairman.
Thank you, Commissioner Coleman. Any further discussion? Hearing none, all those in favor of the motion say aye.
Aye?
Aye. Any objection?
No.
That was no by Commissioner Zerfus. On final adoption, is there any objection to using the previous roll call?
No.
Hearing none, the recommendation is adopted as amended by the motion by a vote of 4-1, noting Commissioner Zerfus's dissent. Thank you.
Thank you, Vice Chair Barrow.
Chairman, the gavel is yours.
Thank you, Vice Chair Barrow. Continuing on today's agenda, on page 6, I move that the Commission adopt a proposed opinion and order regarding the formal complaint of Aristilde Stanley. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion?
Chairman, I do have a joint statement
Commissioner Coleman.
with Commissioner Yanora. I've just asked that our joint statement be entered the record as though we read it in its entirety. We agree with dismissing this formal complaint that is before us, that the complaint's failure to prosecute meet the burden of proof. However, we do not agree with dismissing this complaint without prejudice. Rather, we would dismiss the complaint with prejudice for reasons set forth in our joint written statement. Therefore, I will be concurring in result only.
Thank you, Commissioner Coleman. Any further discussion? Thank you, Commissioner Yanora. Any further discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The matter is approved by a vote of 5-0, noting Commissioners Coleman and Yanora concurring in result only. Continuing on today's agenda and turning to page 7, I move that the Commission adopt the proposed opinion and order regarding the formal complaint of Ronald and Mia Reistetter. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion?
Chairman, I have another joint statement with Commissioner Yanora.
Mr. Coleman.
Thank you. For the same reasons in the last case that I've set forth in my written statement and asked that it be entered into the record as well on this matter, we'll be voting in concurring in result only. Thank you.
Thank you, Commissioner Coleman. Any further discussion? Thank you, Commissioner Yanora. Any further discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it, and the matter is approved by a vote of 5-0, noting Commissioners Coleman and Yanora concurring in result only. Continuing on page 7, I move that the Commission adopt the proposed opinion and order regarding the joint settlement petition of the Bureau of Investigation Enforcement and People's Natural Gas Company. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it, and the matter is approved by a vote of 5-0. Turning to page 8, I move that the Commission adopt the proposed opinion and order regarding the Act 129 Energy Efficiency and Conservation Phase 5 program. Is there a second?
Second.
Seconded by Commissioner. Seconded by Commissioner Zerfus. Any discussion?
Mr. Chairman, I have a motion.
Commissioner Zerfus.
Thank you, Mr. Chairman. Before us today for consideration and disposition is the petition for reconsideration, clarification, and modification filed by the Coalition for Affordable Utility Services and Energy Efficiency in Pennsylvania, CAUSE-PA, and the Tenant Union Representative Network, TURN, on July 3rd, 2025, seeking reconsideration on the implementation order that was entered on June 18th, 2025. On February 20, 2025, the Commission adopted a Phase 5 tentative implementation order seeking feedback for Phase 5 of the Energy Efficiency and Conservation, the EE&C program, which would operate from June 1, 2026 through May 31st, 2031. Following a comment period, the Commission issued its June 2025 implementation order, which contains a consumption and peak demand targets and standards, along with procedures for review and approval for the EE&C plans for Phase 5 of the EE&C program. On July 3, 2025, CAUSE-PA in turn filed the petition. So on July 11, 2025, the Office of Consumer Advocate and the Office of Small Business Advocate jointly filed a letter in lieu of answer in support of the petition. In addition, on July 14, 2025, the Energy Association of Pennsylvania, the EAP, filed a letter in response to the petition. In the petition, CAUSE-PA in turn argued that the Commission overlooked how the Phase 5 planning timeline affects due process rights of interested parties, as well as the need for a complete evidentiary record to properly evaluate EE&C plans. Specifically, CAUSE-PA in turn contend that the Commission erred by extending the EE&C plan filing deadline to November 30th, 2025, without adjusting the related deadlines in the plan approval process. According to CAUSE-PA in turn, unless the order is modified, the schedule will allow parties only 15 or fewer business days to conduct discovery and develop the evidentiary record required for review. The petitioners argue that the Commission truncated the due process rights of stakeholders to conduct discovery in a reasonable timeframe and meaningfully participate in litigation. CAUSE-PA in turn requests that the Commission modify the June 2025 implementation order and argue that these changes are needed to protect due process, allow meaningful review, and ensure a complete evidentiary record. In response, the statutory advocates expressly state that they fully support the request. EAP indicates that it does not object to the interim timeline adjustments proposed by CAUSE-PA in turn, provided that any changes do not alter the filing deadline for proposed Phase 5 EE&C plans or extend the close of the evidentiary record beyond February 4, 2026. I agree with the statutory advocates who state that the petitioners have presented pragmatic and reasonable solutions to amend the implementation order and adjust the litigation schedule across multiple EDC, EE&C plans without extending the required 120-day Phase 5 planning timeline. I believe the petitioner's proposed timeline adjustment should be made even though the current timeline deviates only slightly from those of the previous 4 phases of the program. So therefore, I move that the petition for reconsideration, clarification, and modification filed by CAUSE-PA in turn is hereby granted. 2, that this opinion and order be served in all jurisdictional electric distribution companies, the Office of Consumer Advocate, the Office of Small Business Advocate, the Commission's Bureau of Investigation and Enforcement, Law Bureau, Bureau of Technical Utility Services, and all parties who filed comments regarding Phase 5 of the Commission's Energy Efficiency and Conservation Program under this docket number, and 3, that the Office of Special Assistance draft an order consistent with this motion. Oh, and we should add it to the record as if I read it in its entirety. Thanks.
Thank you, Commissioner Zerfus. We've heard the motion by Commissioner Zerfus. Is there a second?
Second.
Second by Commissioner Yanora. Any discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it, and the motion is adopted by a vote of 5-0. Is there any objection to taking the previous roll call on the matter? Hearing none, the matter as amended by the motion is approved by a vote of 5-0. Continuing on page 8 of today's agenda, I move that the Commission adopt an omnibus motion, beginning with the remaining item on page 8 regarding the petition for reconsideration of Kelvin D. Ferguson and Sons, LLC, and continuing the omnibus to include both items on page 9, ending the omnibus with the petition for emergency interim order of Jeremy Hargrove. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed,
Aye.
no. The ayes have it, and matters are approved by a vote of 5-0. Turning to page 10 of today's agenda, matters presented by Director Diskin and the Bureau of Technical Utility Services. I move that the Commission adopt the proposed order regarding the application filed by PECO Energy Company Electric. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion?
Chairman, I have a statement.
Vice Chair Barrow.
I will not read my statement. Please enter my statement into the record as though read in its entirety. Thank you.
Thank you, Vice Chair Barrow. Any further discussion? Hearing none, all those in favor, please say aye. Aye. Those opposed, those opposed, no. The ayes have it, and matters are approved by a vote of 5-0. Continuing on page 10, I move the Commission adopt an omnibus motion, beginning with the remaining item on page 10 regarding the proposed order concerning the application of PECO Energy Company Electric, and continuing the omnibus to include both items on page 11, both items on page 12, both items on page 13, and all three items on page 14, ending the omnibus with a proposed order regarding the tariff supplement of Energy Center Harrisburg, LLC. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it, and matters are approved by a vote of 5-0. Turning to page 15 of today's agenda, matters presented by Chief A.L.J. Rainey and the Office of Administrative Law Judge. I move that the Commission adopt the recommended decision of A.L.J. Dunderdale regarding the petition of Audubon Water Company. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it, and the matter is approved by a vote of 5-0. Continuing on page 15 of today's agenda, it should be noted that the remaining matter on page 15 regarding the proposed merger of Frontier Communications Parent, Inc. and Verizon Communications, Inc. has been postponed to the public meeting of September 11th, 2025. Turning to page 16, I move that the Commission adopt the initial decision of A.L.J. Arnold regarding the formal complaint of Daryl Shawfield, care of Donna Shawfield Bennett. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion?
So, Chairman, I have a statement.
Commissioner Zerfus.
Thank you, Mr. Chairman. Please enter my statement as if I read it in its entirety. On November 8th, 2024, Donna Shawfield Bennett filed a formal complaint on behalf of Daryl Shawfield, alleging that there were incorrect charges on the electric bills Mr. Shawfield received from Duquesne Light Company. In the complaint, Ms. Bennett identified herself as the trustee for Daryl Shawfield. By interim order number 1, issued on February 25th, 2025, Administrative Law Judge Alfonso Arnold directed Ms. Bennett to have an attorney enter an appearance on behalf of the trust of Daryl Shawfield on or before April 3rd, 2025. On March 31st, 2025, Ms. Bennett filed a request to withdraw the complaint in which she stated, based on the obvious prejudice and bias the court has exhibited in its order number 1, I see it as futile to continue in this course of action. Ms. Bennett also explained that she is the trustee of Daryl S. Shawfield in his Special Needs Trust, who has been paying Mr. Shawfield's electric bill. She further stated that the requirement for an attorney in this proceeding was questionable and prejudicial and placed Mr. Shawfield at a disadvantage in having his claims resolved. In an initial decision issued June 30th, 2025, the ALJ dismissed the complaint on the basis that Ms. Bennett failed to comply with interim order number 1 because an attorney did not enter an appearance on Mr. Shawfield's behalf by the April 3rd, 2025 deadline. I'm concerned that the Commission's current procedural rules are overly restrictive and can result in negative consequences for vulnerable customers, as occurred in this case. Mr. Shawfield and other customers should have the opportunity to be heard on their claims. This is particularly important when concerns such as proper billing, the ability to pay utility bills, and potential termination of utility service if utility bills are not paid are an issue. I am hopeful that the inflexibility in the Commission's current procedural rules will be resolved through the amendments to Chapters 1, 3, and 5. As I emphasize in the statement that I provided earlier in the context of Chapters 1, 3, and 5 in the rulemaking, the Commission must reform our procedural rules to allow representation by non-attorneys in Commission proceedings by implementing procedures that are similar to those used by other administrative agencies. By authorizing additional representation options for individual customers, we will improve the equity in our proceedings while also facilitating the complete development of evidentiary records upon which we base our decisions, thereby increasing the efficiency of our proceedings to the benefit of the Commission and all parties. Thank you.
Thank you, Commissioner Zerfus. Any further discussion?
Chairman?
Vice Chair Barrow.
Thank you. Please enter my statement into the record as so read.
Thank you, Vice Chair Barrow. Any further discussion? Chairman, I do have just a couple of quick verbal remarks.
Commissioner Coleman.
Thank you. This is one of those cases that I wish we could have a do-over. This complainant was originally assigned to the Commission's mediation unit for review, and it was after Duquesne Light had filed its preliminary objections that the complainant was properly assigned to an administrative law judge. Following the administrative law judge's ruling on the preliminary objections, it would have been nice if we could have transferred this case back to our mediation unit for further disposition. That in doing so, I think we may have eliminated this outcome that in some respects may be a bit unfortunate. In that mediation process, the parties could have agreed to get together and had shared their information, and maybe I'm overly optimistic, but maybe they would have found an amicable conclusion. And if not, they could have availed themselves of one of the ALJ's or the Commission's mediation attorneys to work with them to see if they could find an amicable conclusion. Of note, the trust would not have had to hire an attorney in this process, and I think that's really what we're driving at here this morning, is that I think there may have been a path here that could have gotten to a better conclusion than where we are this morning. And I would just remind our administrative law judges to keep in mind the use of that mediation process. Thank you.
Thank you, Commissioner Coleman. Any further discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it, and the matter is approved by a vote of 5-0. Continue on page 16 of today's agenda. I move that the Commission adopt the recommended decision of ALJs Gould and Arnold regarding the joint petition for settlement of the PUC et al. Versus the Pike County Light and Power Company Gas Division. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion?
Mr. Chairman, I have a statement.
Commissioner Zerfus.
Thank you, Mr. Chairman. Please enter it to the record as if I read it in its entirety. I will not read the whole thing, but just kind of summarize it. Like, the long and short of it is that under the terms of this settlement, the reduced amount that was approved as a rate increase will be implemented in 2 phases. Phase 1 effective October 15 of 2025 and Phase 2 October 15 of 2026. I want to highlight that the phasing in of this rate increase as part of the settlement, it was acknowledged that it was based off of direct testimony provided at the Commission-led public input hearings. There was some testimony by one customer in particular who had suggested a phase-in of any new rates to help customers and folks with any financial challenges that they may have as a result of a potential rate increase. And in response to the testimony, the joint petitioners agreed to a gradual phase-in, helping to ameliorate that financial impact on customers. So I just want to take the opportunity to highlight how important it is for folks to show up to public input hearings. I want people to understand that when you show up and you attend and you speak on the record, that information is it's read, it's heard. We take it very seriously. It's weighed as part of the review of a of a rate case. And, the commission always endeavors to balance the needs of consumers and utilities, and it's part of the official record. So I cannot stress the importance enough of public participation in these public input hearings, and appreciate how the parties involved were responsive to the testimony provided. I'll just end it there, I guess. Thank you.
Thank you, Commissioner Zerfus. Any further discussion? I will point out that both on this matter and the next matter, and just feeding off of what Commissioner Zerfus has said, this was filed as a single rate case and turned into a multi-year rate case. I would just point that out to some of our utilities as you're looking to file rate cases and as affordability issues continue to affect ratepayers. We have, PWSA has had multi-year rate plans in effect, a couple for the last 2 rate cases. So we've had it in the water sector. We now have it in the gas sector. We now have it in the electric sector. So I just would remind our jurisdictional utilities to take a look at that. One of the things that the legislature did give us is alternative rate making capabilities, and multi-year rate cases are a part of that. Any further discussion? Hearing none. All those in favor, please say aye.
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 Those opposed, no. The ayes have it, and the matter is approved by a vote of 5-0. Turning to page 17. I move that the commission adopt the recommended decision of ALJ Gould and Arnold regarding the joint petition for settlement of the PUC et al. Versus the Pike County Light and Power Company Electric Division. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none. All those in favor, please say aye.
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 Those opposed, no. The ayes have it, and the matter is approved by a vote of 5-0. Turning to page 18, and the final item on today's agenda, I ask Vice Chair Barrow to preside so I can offer my C motion. Vice Chair Barrow.
Chairman DeFrank, you're recognized for purposes of your motion.
Thank you, Vice Chair Barrow. At the July 10th, 2025 public meeting, the Commission ratified appointments to the Commission's Consumer Advisory Council for a new 2-year term beginning July 1, 2025. The Commission ratified 3 executive and legislative appointments, reappointed 5 at-large members, and made 2 appointments of new at-large members. The Commission thanked those members who were ending their service to the CAC, and thanked those members for their future service who were joining or continuing their service on the CAC. Today, I move to ratify 2 additional appointments to the CAC for the 2025 to 2027 term. Both of these appointments are from the chairs of the Commission's Senate Oversight Committee. Since the July 10th public meeting, the Commission has received the appointment to the CAC by Senator Patrick Stefano, Majority Chairman, Senate Consumer Protection and Professional Licensure Committee, of Jen Marsh of Bedford, Pennsylvania. Ms. Marsh is the President and CEO of the Bedford County Development Association. Ms. Marsh has over 15 years of experience in building public-private partnerships, developing rural infrastructure, and engaging stakeholders. Additionally, the Commission received the appointment to the CAC by Senator Lisa Boscola, Democratic Chair, Senate Consumer Protection and Professional Licensure Committee, of Baron L. Vanderburg of Easton, Northampton County. Mr. Vanderburg is Associate Director of Admissions and Director of Inclusion, Access, and Diversity Initiatives for Muhlenberg College. Mr. Vanderburg has a strong record of public service, high education leadership, and community engagement. Thank you in advance to both Ms. Marsh and Mr. Vanderburg for their involvement on the CAC and their willingness to devote their time and efforts to give consumers an active voice at the Commission. Therefore, I move that 1, pursuant to 52 PA Code Section 91.4C 1 through 3, the Public Utility Commission ratifies and accepts the following appointments to the Consumer Advisory Council for the term beginning July 1, 2025 and continuing through June 30, 2027. From Chairman Patrick Stefano, Jen Marsh. From Chair Lisa Boscola, Baron L. Vanderburg. 2, that the Law Bureau prepare an order consistent with this motion. Thank you, Vice Chair Barrow.
Thank you, Chairman. You've heard the motion. Is there a second?
Second.
Second by Commissioner Zerfus. Any discussion on the motion? Hearing none, all those in favor of the motion say aye.
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 Aye. Any objections? On final adoption, is there any objection to using the previous roll call vote?
Nope.
Hearing none, the motion is adopted by a vote of 5-0. Thank you.
Thank you, Vice Chair Barrow. That concludes all agenda items to be considered today. Before we adjourn, I would like to recognize Commissioner Zerfus for a statement on Women's Equality Day. Commissioner Zerfus.
Thank you, Mr. Chairman. The right to vote, the foundation of a democracy, belongs to all citizens, but this wasn't always the case in our country. It was in the early 19th century when women began fighting for the right to vote, and it led to the ratification of the 19th Amendment, which took place on August 26, 1920. I would be remiss if I did not acknowledge that while millions of women across the country were finally able to make their voices heard at the polls with the ratification of the 19th Amendment, many women of color who helped lead the universal suffrage movement were effectively denied those rights until the Voting Rights Act passed 45 years later. However, Women's Equality Day gives us an opportunity to collectively celebrate the progress of women over the years and renew our commitment to advancing gender equity and protecting women's rights regardless of their race, income, or zip code. We have certainly come a long way, but there's always more work to do. So I ask you to join me continuing to help break down barriers and build a society where every person's worth and contributions are valued, because equality in words is not always as equality in practice. Thank you.
Thank you, Commissioner Zerfus. Next week, the PUC will host our 2025 Safety Conference on September 3rd and 4th at the Penn Stater Hotel and Conference Center in State College. Our Bureau of Investigation and Enforcement staff does an excellent job putting together the two-day seminar each year. Attendees will be hearing from many of our expert staff, and topics will cover everything from pipeline and electric safety to cybersecurity. I'm looking forward to providing opening remarks on Wednesday, and I know that other commissioners will be attending the conference as well. We hope to see you there. And finally, this coming Monday, we will recognize Labor Day. Here in Pennsylvania, Labor Day has been observed since the 1880s, even before it became a national holiday, with celebrations starting in the Philadelphia region. The history of Labor Day in Pennsylvania is deeply intertwined with the state's strong labor union movement. Our rich industrial heritage in coal mining, steel production, and manufacturing has allowed our state to play a pivotal role in improving working conditions, wages, and safety for workers. Through the years, the holiday continues to honor the contributions of workers and their rights. In honoring the upcoming Labor Day holiday, I want to thank all Commission employees for their hard work they do throughout the year to carry out our important mission. I also want to thank the utility workers and those who provide vital utility services to Pennsylvania consumers. On behalf of my fellow commissioners, we wish you a safe and enjoyable Labor Day holiday weekend. If there is no other business to come before the commission, is there any objection to adjourning today's meeting? Hearing none, we are adjourned.